I want to thank everyone for coming. I wanted to let you know that when I left last week to start these seminars, the real estate law update for 2018, we had about 400. So I thought, okay, well, I didn't ask anybody to turn off the registration, and SAR, you had a total of 850 people register. That is amazing. That is amazing. So I want to thank you for registering and coming today. My name is Ben Herb. I'm with C.R.E.B. That's the owner side, the ownership side of the owner brokers, and then of MetroList, and then MetroList is the other half is owned by you members. So I work for C.R.E.B. C.R.E.B. asked me, hey, please work with our agents. So I work with for all of you as well. So if you have questions regarding DRE, CAR, or MetroList, or something else, please feel free to call me. Well, one thing I was going to tell you is that we are filming live today. So if anybody from your office wasn't able to come for whatever reason, or they forgot, we are filming it live so you can watch it, and we will send it out to everybody who has made a reservation to come. So if you didn't, it's okay. You can have a friend or whatever that went, or call us and we'll still send it to you. Secondly, the attorneys will tell you what they're going to do. If you put your card in their box, they will send you the PowerPoint to this, which would be good for either your office for a meeting or whatever. You can run through it as fast or as slow as you like. So without further ado, I want to bring up Alex Munn and, and Keith Dunnigan from the BPE Law Group.
Good morning. What's happening?
Come on, you can do better than that. I know it's Monday morning and we're tired, but good morning.
I'm Alex Munn. This is Keith Dunnigan. We are lawyers. Hey, boo. But we're nice guys. And we'd love to speak at SAR. And we hope today will be both informative, educational, and maybe funny at times. So, 10:15, let's get rocking and rolling. So, here's what we're going to talk about this morning. Litigation. Litigation is sometimes good and sometimes bad. So we're going to talk about partitions. That's not an office divider. And specific performance, which is critical in today's market. Then best practices. CAR forms. We love CAR forms. We hate CAR forms. So we'll talk about those. Then we'll talk about our favorite topic, second favorite topic, disclosures. Then some market issues, tax reform, and then last but not least, we'll get into the weeds on cannabis. All right, we're getting early. It worked. Partition of co-owned property. That's just what this photo depicts. So what is a partition? So, now we got too many. So it's co-ownership. It can take many forms. A joint purchase, my favorite. Boy meets girl and they fall in love, right? You're going to be my forever person. We'll get a dog. We'll love each other forever. But instead of getting married right away, let's do a test run. And we'll buy a house together. Sounds fantastic, doesn't it? The second one that we see mostly in our office, inheritance. About half my practice is probate and estate planning. And so suddenly mom dies and my brother and I get a house. What happens then? My brother and I are different people. We have different thoughts about what to do. What happens next? So, boy meets girl, fall in love, things are great. But there could be problems down the road. Boy and girl fall out of love. Now they own this joint asset. One wants to sell, one doesn't want to sell. What happens then? Occupancy and tenants. My brother and I, we inherit a house. It's got a tenant, long term. I want to keep the house. Why? I think the investment's a long-term hold. I want the continuous cash flow, and I want equity over time. That's my retirement. My brother does not want that. Why? Housing prices have skyrocketed. There's equity. So that person wants the equity, my brother. He thinks that he can make more money from the equity than the long-term hold. We're at loggerheads. What happens next? Maintenance costs. The house needs a new roof, 25 grand. I don't want to put 25 grand into the house. My brother does. What happens then? So, scenario. Client comes to you with a listing. It's their co-owner. Other co-owner refuses to sell. Number one, you got a listing. Listings are good. Number two, do not put this in your pipeline. Everybody has a pipeline, right? Trying to figure out what's going to close when to make that boat payment when you get that commission check. Don't put this one in your pipeline, as we'll talk about. So, two options. Resolve without court action, that's a buyout. Or you file a partition lawsuit. What does a buyout look like? Number one, what's the property worth? That's the bottom line, right? So you have to have a baseline of what that value is. So let's say the value is $400,000, there's a $200,000 note. You've got 200 grand to split. 100 to me, 100 to my brother. But reimbursement of expenses. The boy versus girl. They loved each other. They merged their bank accounts. Some bills were paid by one person, some bills were paid by the other. Things got murky. They were in the cloud of love. So when you start getting down to the nitty-gritty, you're going to have disputes over who paid for what. No, I paid for the deck. No, I did. I got the insurance that year. No, I did. That becomes complicated. As we'll talk about, if we file a partition lawsuit down the road, churning up that money is me, right? Because I'm expensive. So you start to fight over the wagon wheel coffee table, and that's worth $300. And that's an hour of my time, right? It's a marriage. We'll talk about how that works. If you can't agree on value, and you can't agree on reimbursement of expenses, then we do a lawsuit. Partition and accounting, it's two pieces. I'll figure this out. So, partition action. CCP, that's lawyer speak for Code of Civil Procedure. It's a statute here in California. 872, et sec. That's fancy Latin for and other. No one can be compelled to remain a co-owner of real estate if they don't want to. You can't hold a co-owner hostage. Why? Real estate is valuable, and real estate is unique. The law places a premium on real estate. It needs to be for its highest and best use. If one person wants to sell and one person does it, you can't hold the other person hostage. So, I want to sell. My brother doesn't want to sell. My brother blocks my attempts to sell the property. I file a partition lawsuit against my brother. I want the property to be sold. It's a single-family residence. You can't chop the house in half, right? You can't partition a single-family residence. So the court is going to order it sold. However, if it's raw land, that's a different story.
Yeah, so what will happen in a large property setting is there's this thing called partition in kind. Partition in kind means we've got a large chunk of land, we're going to cut it in half or thirds or quarters, depending on how many owners there are, and we're going to split that up. But it's very, very rare. We have zoning laws that say you can only cut parcels down to a certain level. We have subdivision maps that already cut the property up. It makes it very difficult. In fact, it's so difficult, I've been doing partition cases and real estate cases now for about 14 years, and I've only seen 2. One of them is going on right now. Business owners buy vacant land to use for business purposes, and business owners decide they can no longer cooperate. That one you can do it. But the reality is what you're going to see is you're not likely to see these large tracts of land, these large 300-acre farms, 1,000-acre farms, getting into a partition action through an inheritance. What you're more likely to see is to see the scenario where little Johnny and little Joey inherit mom and dad's house. And as Alex said, try as we might, we can't cut it in half with a chainsaw.
So the court chooses the fairest method, but when you're talking about a single-family house, that fairest method is to sell. So what's the hammer, right? What's the hammer? Attorney's fees, right? Well, court costs we'll talk about, didn't leave that out yet. So attorney's fees. We're nice guys, but we're expensive. And that's just the reality, right? So the hammer for me, I want the house to be sold, is I race to the courthouse. I get that lawsuit on file first because I am the aggrieved party and my brother is blowing me off. So I file the lawsuit. The hammer for that lawsuit, for him to cooperate, is that when I win, because he's being a jerk and won't sell, out of that division of proceeds, I get paid from his portion. Now, partition lawsuits are incredibly expensive. The senior litigator in our office just finished a 2-year case. Started off with one house here in Sacramento. It ballooned into a property in Washington State. The recalcitrant dad on the other side had outstanding child support. So it was all rolled into one. And it was like a divorce. And they fought over the wagon wheel coffee table, the rusty wheelbarrow, the crappy trinkets. I'm joking, but our fees in that case, $75,000. Scooped from the other side. So, somebody comes to you with a listing with a co-owner who won't cooperate. You're not going to practice law. You say, wow, this is going to be really expensive if they fight. And it takes forever. If we were to file today in Sacramento County, we may see a judge in 18 months. Maybe. Not enough judges, right? Criminal cases take constitutional priority, fair and speedy trial. And with 3 strikes, people are trying those cases. So we civil guys and girls, we get pushed to the end. So it takes forever. Pipeline, pipeline, pipeline. And not only is it expensive and time-consuming, mental rent on your seller, right? I'm fighting with my brother. I'm fighting with whomever my other co-owner is. That's super expensive. But attorney's fees are the key here. So, what you're looking for is the judge to push. You want her to make a ruling on your behalf to sell the house. Court supervision. When judges look down from the bench, it's an intimidating thing, especially when my brother's been a jerk. And it normally allows things to move quickly or more quickly. So you get a licensed appraiser, set the value, right? Number one. Then you list it for sale with a real estate professional. Here is where you come in. So you get the listing. Co-owner has to file the partition action. I'm retained. I tell you to put your newest and brightest and shiniest CV or resume together. Because when we petition the court needs to appoint a special master to sell the house. That's you. We want you to be appointed the special master. Why? It looks great on your resume. Number two, if the court likes the job that you've done and they have another partition case, maybe the court will appoint you again as the special master. And other areas of compensation too, right, Keith?
Yeah, so one of the things you want to be looking for when you're looking into these partition cases is look at the character of the property. Because so often you get that listing, and as the listing agent, you're looking at this and going, okay, great. But the courts, we want to make sure that you get compensated for everything you do. So I tell this story a lot about one of the first partition cases I did in California several years ago back in San Francisco. How many of you have had the good fortune of dealing with the San Francisco Rent Board? Lucky you. Well, not unlucky you. Lucky rest of you. The Rent Board is nothing to be messed with. We had this case, and we get this agent appointed to be the referee. She's going to make her standard action. But this property had been a rental for many, 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 many years with a tenant who was well-funded and knew his rights and wasn't afraid to threaten rent board actions. The judge also awarded her, on top of her listing commission, $195 an hour for property management fees. Now, it's San Francisco. The market's different than it is in the rest of California. So $195 an hour in property management fees in Sacramento County, probably not going to get that. But the idea is you have to look at where are all the opportunities in these partition cases. Because we talk about how long it takes and what those issues are, and you're sitting here going, well, great, how am I benefited? It's getting in as that referee. So you want to make sure that when you make that referral, as Alex mentioned, stick your CV on top so that the attorney who takes that referral can then make that position known to the judge.
Last new line of business. If you do enough of these, then you may be able to qualify as an expert witness to provide testimony in cases like these. Expert witnesses are paid handsomely with minimum hours. So I have a 4-hour minimum, for example, and my hourly rate's $200. That's a nice, everybody likes $800, but that's new revenue stream, new revenue stream, new revenue stream on a co-ownership property that you may think, I don't want to deal with this hassle. But if you look at it a different way, it creates opportunity. So, the accounting phase I think we've talked about. Books get blurred, especially if you've been co-owners for 10 years. Who keeps paperwork from that? Memories fade. This is where the money is spent, fighting over the smallest detail. That's when we as attorneys have to have some client control. Because if I'm fighting over the wagon wheel coffee table, it's a terrible example, but it works. And it's only worth $50 at a garage sale. And yet I spent an hour writing a motion or drafting a pleading, trying to get that back. Well, it's not worth the time or the money or the expense or the mental rent. So if you get one of these or you're involved in one of these, you got to pick your battles. You got to know what to fight for and what not to fight for. The goal is to get the house sold. Bottom line, take a long time, expensive. Don't put it in your pipeline, but look for opportunity. I think you just point it straight.
Just point straight?
I think so.
Specific performance when the seller breaches the RPA. How many of you know what specific performance is? Hope it's for good reasons and not bad reasons, because it is dangerous. What is specific performance? Specific performance is a remedy allowed by law to force a non-performing to perform a contract. It's draconian. In the American legal system, we tend to take a very simple approach. We believe that when somebody has been harmed, they can be adequately compensated for that harm with money. So that's what we use. Somebody gets in a car accident. Money can fix that, kind of. Somebody breaches a contract to sell a widget. You can replace that widget with another widget, so we'll give you money. But property is different. There's only one 123 ABC Street. So if the seller breaches that, how do we adequately compensate the non-breaching buyer for that harm? Specific performance. California Civil Code section paints this picture for us. Typically, I don't recite codes because they get lost on me sometimes. But this one is particularly interesting and one you should be aware of. It is presumed that the breach of an agreement to transfer real property cannot be adequately relieved by pecuniary compensation. Whoa. The entire legal system, which is founded on money and using it to redress a harm, this one doesn't work. The statute plainly says that when somebody breaches an RPA, the only way that you can relieve that harm is through the use of the property. You cannot adequately redress that harm with money. The statute goes on to say, in the case of a single-family dwelling, which the party seeking performance intends to occupy, buyer's going to use it for a primary residence. This presumption is conclusive. It's dangerous. If you're the listing agent and you're representing a seller, and your seller says, I want to breach, that's dangerous for them. The law, the legislature has gone so far as to say, and calls you and says, my client wants to make an offer. They're going to offer over list. And you go, woohoo! Life is great. I didn't even have to do an open house. This is wonderful. That RPA comes flowing right into your email box, and you check it out and go, it is. It's $10,000 over list. You see that? You pick up the phone, and you call your client immediately. You go, you'll never guess what happened. I just got an offer, and it's over list. And your client, after processing that for about 20 seconds, does a jig in his head. Life is great. So as fast as you can hit the send button to send it to his email box, he opens it up, he checks all the little boxes, signs it on DocuSign, and sends it back, and you have a fully ratified contract. Life is good. Until 3 days later, and 3 more offers come in. And one of those offers is $35,000 over list. And you go, oh crap. Now I have to tell my client this. I've been there before. I know what they're going to want to do, and they can't do that. This is not going to be good. So you fulfill your fiduciary obligation, and you pick up the phone, and you call your client. And you tell the client these fabulous tales of these new offers, and one of them is $35,000 more than list. And he goes, let's cancel the first one. Whoops, not going to be good. Because much like in the partition, where we have a statute that shifts attorney's fees, well, the car contract buried on the last page has a very powerful, we'll get there in just a minute, has a very powerful attorney's fees clause that says that if you end up in litigation, buyer and seller, the prevailing party will collect from the losing party reasonable attorney's fees. That's not good. I get sellers into my office on these cases, and I sit here and say, you should just complete the contract. And the enterprising seller, being somewhat aware of how the litigation process works, goes, but they still have to collect. I can go bankrupt. If they get a judgment, they're never going to get paid. And I said, oh, ye fool one. You don't understand how this works. Because where does the money go before it goes to the seller? Escrow. And a smart lawyer, like Mr. Munn, what is he going to do? He's going to garnish it. He's going to get an order from the court that says, before you give any money to the seller, pay off the buyer's costs. It's very dangerous. Oh, I already talked about attorney's fees. I'm getting ahead of myself. So the question is how is this actually enforced? Your seller comes to you and says, I want to cancel, and you being the astute listing agent who's read the contracts and understands what's going on and has showed up today to hear our spiel on specific performance goes, you need to talk to a lawyer because you can't do that. They're going to force the sale. But after much back and forth, and you documenting in writing that this is a bad idea, that you have a contract and you have to perform, you relent and you issue the cancellation and your client signs and it goes over to the other side. But your buyer is now particularly miffed. The seller has just canceled and the buyer shows up in the attorney's office and they're worried. They know that lawsuits take a long time. They know that they're expensive. They understand that when they win, and I say win, because the statute is very, very clear that the seller is going to lose 99.9999999% of the time. I leave one way out there somewhere because judges are funny people and they do weird stuff. But the buyer comes in and says, what's the certainty? This seller has already shown that they're going to breach the contract, that they're going to go a different direction. What's the certainty that if I get in this lawsuit, that I'm going to be able to close the transaction and buy this property and prevent the seller from selling to somebody else? Mr. Munn?
Oh, it's the list pendants. Who knows what a list pendants is? List pendances are the hammer that you have. Remember, we're trying to talk leverage, right? Trying to get the deal closed. So a list pendants is basically a document that's recorded which puts the world on notice that a lawsuit is out there. And the house cannot be sold with the recordation of that list pendants. So the seller who canceled the valid contract says, I'm just going to sell anyway, and they can chase after me for the money. I'm not collectible. I'll go bankrupt. I'll go to Argentina. No. So enterprising lawyers like myself file the lawsuit, record the list pendants, and that blocks any potential sale. So that's the hammer in these cases, because it ties up the seller too. So now the seller's sitting on a house that she was looking to sell at the first place, and now she can't because of the list pendants. And then lawyers start showing up. So normally, if you represent a buyer and the seller breaches, and you file the list pendants in the lawsuit, that is the come to Jesus of the seller. The seller now thinks to himself, I got a list pendants, I can't sell the property. I've got to retain counsel. We had a valid contract for 10 over list, but I canceled, and now I'm going to be liable for attorney's fees. Normally, the uncle comes then, ow, uncle, and they give up. But you have to go through those processes to get to that end point. The faster you file the specific performance lawsuit, the faster it goes away. No. Responsibility of counsel.
Yeah, the way the statute sets up on list pendants, the attorney has to sign it. An individual can't sign it without permission from the court.
Is it the responsibility for the broker or the buyer to file and record the list pendants?
We got two questions over there.
Yeah. Well, if they've already signed that additional contract with the list pendants in place, that's off to the side because we're litigating the underlying 10,000 over. That's the one.
And the reality is once that list pendants goes on, it's deemed constructive notice to everybody that there is somebody out there who is claiming a senior title position. So if they did go through with that transaction, that buyer on that second transaction is no longer a BFP, a bona fide purchaser for value, and their transaction can be unwound. Right behind you.
Sir. If he's not accepting an offer, sure. The question was, if the buyer hasn't accepted, or if the seller hasn't accepted the buyer's offer, can the seller continue to entertain additional offers? Sure.
Absolutely.
Sure. Yes. So the question was, what happens to the seller's agent? So in that case, so you have offer one that's been accepted, and then as Keith mentioned, seller wants to cancel. Seller's agent has counseled not to cancel, yet they issue the cancellation anyway. Agent gets in some interesting positions there. Because remember, you are an agent of your principal, right? That's a big deal. And so if your principal directs you to cancel, you do, then another offer is accepted, that gets super tricky because you are giving fiduciary duty advice to your client to cancel and then reaccept. Then your commission gets murky, things just get murky. And so that's a tough place to be. Yes? No, it's recorded. You file it with the court, then you record it with the county recorder.
No, and the notary. No, so the way we do it as lawyers, when we do a lis pendens, because we can sign them ourselves. We don't have to have anybody witness our signature. We just sign it as a member of the state bar. We take it down. We can get it stamped that day and then recorded.
Yeah, so the question was, because of all the court delays, what happens if there's an interim period and the house is then sold? We can get things filed same day. And so we sign the lis pendens, get it from the court, walk 2 blocks down to the county recorder, record at the county, constructive notice to any potential buyers, cuts off any bona fide purchasers, property is now in limbo. Sir?
How does the seller find out that it's been filed?
Notified by me, the buyer's attorney. Yes?
Are the agents and the brokers at risk for this type of activity if we have documented that we advise our clients to not cancel?
If you've advised your clients not to cancel, no. The question was, are the agents and brokers at risk in these types of transactions if they've advised their clients not to cancel? And I would say no. If you've CYA'd and said do not cancel, yet you take instruction from your principal to cancel anyway, you should be fine. Refuse to issue the cancellation? Sure. Yes.
What happens if the buyer doesn't do this immediately and then a month later finds out that the property's sold and sold for more? Do they have recourse at that time? And what happens to the seller?
So the question was, what happens if the buyer finds out later that they've accepted another offer and the transaction's closed? Well, I don't know if you'd have a specific performance lawsuit there.
You don't have a specific performance lawsuit at that point because the buyer on that second transaction is a bona fide purchaser. They're not aware of that dispute. So you can't force that property back from the innocent buyer. What you could do, though, is you could sue the seller for breach and then disgorge profits. But the question in that scenario is, what's the actual monetary harm? How much did you lose? Was it a difference between your $10,000 over list and their $35,000 over list, so you're litigating for $25,000? From a practical standpoint, do you want to spend 2 years in litigation over 25 grand?
It's tough. Economics. Sir?
So does that mean once you know the seller has an intention to cancel, you as a buyer just go have the attorney file that lis pendens right away?
Well, I wouldn't say the intent to cancel. So they have to cancel first to give a basis to file the lis pendens.
Yeah. And in that, if I can just add real quick to that, one of the things you want to be aware of, and we talk a little bit this in the next section when we're talking about best practices, is understanding the terms of the contract. Because oftentimes people will come in and they'll come in with their agent, and we invite agents to come in with their clients when they make the referral so that the agents can get this information as well. And they'll say, well, they initialed the arbitration clause and they initialed the mediation clause, so don't we have to mediate? There's an exception. The exception is if it's dealing with specific performance, I see, I'll get you next. If it's dealing with specific performance, yes, you still have to mediate, but you can immediately file your lawsuit to put the lis pendens on to protect your interest before you mediate. Back there. Mhm. Correct. So that assumption was that there was no lis pendens, that the seller closed with somebody else, so that new buyer was a bona fide purchaser for value. So here's an interesting question. Question was, and how many could hear back there? So the question was, you've listed the property, you've gone out, you've gotten a ready, able, and willing buyer, and then the seller decides, I just don't really want to sell. You've brought the buyer to the transaction. What about your commission? And technically, your commission's earned, but the question for you becomes a business one at that point. You know, because how much is that commission on that property? And while you have the right to go sue your client in small claims court to recover your commission, for each and every real estate agent out there and their broker, they have to make the determination, do I want to chase that? Because while you may be entitled to it, what's the economic harm to you? Bad reviews, bad word of mouth, things of that nature. So the answer is yes, you can chase it. The answer is also, is it a good idea? And that's a case-by-case scenario. We'll take two more. We're going to hang out afterwards, so bring your questions up then. But we want to be sensitive to everybody's time, and we're going to keep rolling because we've got a lot of material to cover. So let's go. I've seen your hand way in the back. We'll talk about that in the next one.
Well, the specific performance lawsuit, well, the buyer so the question was, how is the buyer protected pursuant to the liquidated damages clause? Well, the buyer wants the property. So the specific performance lawsuit is to get the property for the buyer. That's the whole deal. So one more, yes? Oof. Yeah, so the question was, so the listing agent gets an offer, and then before they have an opportunity to acknowledge the offer, a higher offer comes in. What happens?
Well, if the offer came from the buyer and they haven't accepted,
Right,
you've got no contract.
right. But if the buyer signed and accepted, and the seller signed and accepted,
Then you have contract.
then
You have contract. You may have contract because then that gets us into the weeds on consideration and a whole bunch of legal stuff.
Yeah,
That's when
so-
you send them to an attorney as fast as you can.
so that one gets super murky. You know, the first year contract law in law school is a thing called the mailbox rule. And so you accept the offer and stick it in the mailbox. Is that a delivered acceptance? Maybe. So we're going to move on, but again, we're going to be standing around afterwards to answer as many questions as we can. Okay, Bart Simpson. I will adopt best practices. So, this gets us back to the car forms that we love. I just think you need to, some of the stuff we might be going over that seems basic. We've had lots of questions. So knowing the CAR forms and what they are and what they do is critical. So key areas to understand. 1, contingencies. And 2, how to get the deal closed, because that's what we want, right? We want a nice, smooth transaction. So I'm sure that you've all memorized the purchase agreement. Read it at night with a glass of wine. So section 14B4 states that, of course, contingencies remain effective until removed in writing. But how do you force the buyer to remove? Yes. Notice of buyer to perform. Again, we're talking pressure points here to try to get the transaction closed. This allows pressure to be applied on the buyer to remove the contingencies using the notice of the buyer to perform. So again, the RPA, that is your friend. What it has in there is important. There's not a lot of fluff. 14D1 and 2. The seller may not cancel a contract based upon a buyer's non-performance without first delivering the MBP, right? So, you send a notice of buyer to perform. They still don't perform. Then and only then do you issue your cancellation. We see lots of cases where this is not followed and the transaction gets gummy. And so you need to specifically think about what position you're in, what form you need to file, and get over to the other side. So if the seller then issues a cancellation of contract, then of course the fight, escrow. We see lots of agents or sellers fighting over their escrow deposit. I've got a case right now, $10,000, earnest money deposit. My client did everything right. Issued the notice of buyer to perform, then the cancellation, everything went silent. That earnest money deposit is the seller's. It's $10,000. What did we do? I was retained. I sent off a lawyer letter to the buyer, non-performing buyer. The buyer put the head under the sand. I wrote certified letters. We've got to mediate this case. There is an exception, however, to the mediation clause. What exception is that? Small claims. But buyer put his head under the sand. My client was angry at the buyer, wants that $10,000. So once the mediation was waived, my client wanted to stick it to the buyer. So she initialed, and so did the buyer, the arbitration clause. So now we're in private arbitration, chasing the $10,000. There's an attorney's fees clause. So Alex makes his boat payment. I don't have a boat. But we're chasing $10,000 with a private arbitrator who's a private judge. And every time that private judge touches that piece of paper, $500 an hour. Right? So that's the craziness, the sausage that we see being made every day. And it is what it is. But again, you got to look at the contracts, understand how they work. So, if buyer does remove the contingencies, but either party then fails to move forward, then what? Demand to close escrow. That's how that flow works. So, in closing for this piece, if seller fails to close its specific performance, buyer fails to close, cancellation, recovery of the deposit, but there's one more scenario that you need to really be aware of. Whoop. Come on. What happens if both parties fail to timely close? You've got a great relationship with the seller, great relationship with the buyer, your buddies, you see each other here at SAR all the time. Contingencies have been waived. Escrow's supposed to close last week. It never did. You're in Tahoe hanging out. You're friends with the other side. The time comes and goes. What happens next, Keith?
Very, very bad things happen. Pittman versus Canham is the case that as a young lawyer, I learned the hard way. Alex and I, we love getting up and we love speaking with agents. And we love to tell elegant tales of our victories. It's fun. We don't so much like to tell the elegant tales of our failures. But where do we learn? The things that we make mistakes on are the places that we learn. So today, I tell a story that I learned from. I was a young kid. They always start out that way. Enterprising young lawyer, I'd spent 3 years practicing law in Washington before I came to California. And I was aware of this thing called specific performance. So I get this client that comes in. They have a contract. They want to now close. And the seller is saying, I'm not going to do that. So I dance a little happy dance in my head, going, I like to win. And this one can win. So I immediately go right to my computer and I pound out a letter telling the seller all of the evil things that they have done to my buyer and how I'm going to take them into a courtroom and destroy them. And I fire it off. And I'm happy. And my client's happy. It was a nasty letter. That's why you hire lawyers, right? 3 days later, a much more senior gentleman sends me a very short letter telling me that I'm wrong and attaches a 6-page case.
6 pages is incredibly short. It must be something about those 6 pages, right?
Yeah.
Normally cases are 60 pages. This was 6.
Pittman versus Canham, case decided in 1992, stands for the proposition the failure of both parties to perform concurrent conditions. They both have an obligation to close by the date that's defined as the closing deadline. During the time for performance results in the discharge of the party's duty to perform. Uh-oh. That sentence in 6 pages just told me I lost. The law says that when you have an outside deadline to perform, and you have a time of the essence clause that says that the performance of this contract is imperative to be done by that deadline, there is a time of the essence clause in the CAR form. If both parties fail to do that, this contract lapses and is no longer enforceable. And after I cried a couple tears, I had the unfortunate duty to pick up the phone and tell my client, I'm sorry, I'm wrong, and I'm going to write off your bill.
So, everybody builds timelines into their pipeline, right? And so if you have this situation, you need to mark that date of close. If contingencies have been waived and you're marching towards close, you got to have that date on your calendar. Why? You don't want to run into a situation where you've got Pittman v. Canham, because then neither party needs to perform. And you're either going to have a really angry buyer or you're going to have a really angry seller, right? So this is case law, not statutes that we've been talking about, but the case law is super powerful. That says if we have concurrent conditions, like Keith stated, both parties need to act concurrently to close the deal. And that day goes by, the deal is done. There is no contract, it is discharged. So we often talk, and it's come up, we've been in Stockton and Modesto and EDCAR and PCAR, and the associations are great. And the camaraderie amongst agents and brokers, really what makes you who you are. But at the same time, these are hard deadlines. And we get asked afterwards, but I'm friends with them. I play golf with them. We're on the Cantry Drive committee together. Yeah, but remember, you are an agent. That's not a word, it's a duty. You're an agent for your principal. And so when you push these deadlines on your buddy on the other side of the transaction, it is what it is. Your obligation is to your principal to close the deal, not for your friendship. Oh, they're going to ruffle their feathers if I. No, no, no. You're creating little liability for yourself, not expanding the liability pool by not following these deadlines. It's important.
Question? Right here.
What if either party filed time extension?
Oh, extension's fine.
What if one party didn't approve? So let's say buyer extend for extension, seller say no.
Yeah, then you cancel the contract.
Well, the buyer in that situation probably doesn't want to cancel.
Right? Well, yes.
So you issue the demand to close escrow to put the seller in a position where they have to close, and if they don't close, then you sue them for specific performance.
So,
Simple answer.
we'll get to you later afterwards. So, this is a hot topic, obviously, right? Gives you lots of stress and your buyers and sellers. So the 3-word mantra, disclose, 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 right? So, obviously the TDS and the SPQ. We've had lots of questions about the AVID, lots and lots. I like the 4-word or less rule. Crack in driveway, good. Crack in driveway from tree root in neighbor's yard, undermining the driveway and needs repair, bad. Black spot on wall, good. Black spot on mold, which is apparent fungal growth due to the potential, bad. And we laugh about this, right? We do. Because you, as agents to your principal, want to list everything that you think is possible within bedroom number 2. But you're not the expert. Agent visual inspection, disclosure. Visual inspection. You don't know if it's mold. You don't know where the crack in the driveway was. You don't know that stuff. That's why we rely, and you rely on outside experts. And there have been lots of them. No longer is a home inspection. You need a roof cert, HVAC guy, electrical gal, sewer person. Liability circle small. If you start to say crack in driveway from tree and liability circle big. We want to keep your liability circle small. Another important thing to remember, this is an agent visual inspection disclosure. Don't open the kitchen cabinets. Because why? It's a visual inspection of what you can see. Accessible areas. You don't need to crawl into the crawl space, but you walk into the room and you do your agent visual inspection. Imagine this scenario. You're a rock and roll agent, you're super thorough, you're doing your AVID, you get into the kitchen, you look under the kitchen sink. All good. 3 bedrooms, 3 bathrooms. You check into bathroom number 2, sink number 2 in the bathroom, look underneath, all good. You forget to look under the sink in bathroom number 3. Bathroom number 3 contains mold and craziness. But in your AVID, you didn't put that. Can you see the liability circle growing larger for you? You looked at this one, you looked at that one, you didn't look at that one. You didn't do an adequate inspection based upon your other room inspections. So don't turn on the water. Don't open the cabinets. Don't put your hand in the refrigerator to see if it's cold. You wouldn't inspect the HVAC system, would you? There's lots of laughs. but it's true. We've also had some comments, I'll get with you in a second, also had some comments about should you do your AVID in handwriting or when you get home, can you do that? My practice and what I preach is to do it in handwriting while you're at the property. Contemporaneous writing. You were actually there. Imagine these questions from me under cross-examination. How many houses did you inspect that day? 4. Did you do AVIDs for each one? Yes, I did. That's my practice. Did you write them then when you were there at the house? No. Did you do them when you got home? Yes, I did. What time was it? 10:30. Did you take notes? No, I didn't. I've got a good memory. So how do you know bedroom number 1 on 123 Elm Street and bedroom number 1 in Greenhaven? Well, I want to see contemporaneous writing. We also have the question of, if you don't note anything, what do you put? Nothing? A scratch? I like to put nothing to note. Contemporaneous writing. I don't want the scratch across the page. Why? Well, I could have tripped and the pen could have. I want the contemporaneous writing. We also had a question in Stockton that said, if I just scratch the whole thing out and says, you know, buyer's agent is not a licensed professional, please consult the homeowner's inspection. No. Here's another interesting one. Had an agent that was doing their AVID when the home inspector was there. That's bad, because the home inspector kept verbally telling the agent what was wrong in each individual room. So now the issue becomes, what do I do as an agent with that information? It's coming from a third party, not me. Do I write something down? Because remember, you as agents also have a common law duty of disclosure. Material defects. So the answer that we came up with, and it's an interesting fact pattern, was if you heard from home inspector that, period. CYA, small liability circle, but I hope that gives you some tips on the AVID. Again, it's critical to remember that you've got a common law duty to disclose. Material defects of the property. Material defect is desirability or price.
There's a question in the back.
Yeah, question in the back. Well, if you can smell creosote and hear railroad all the time, that falls underneath your common law duty of disclosure. If you think that that is a material defect in hearing the railroad, disclose, disclose, disclose. Push that onto the other side, not for you.
This brings up an interesting point, because we get this a lot. People will say, well, what about this? What about that? Do we want to actually disclose that? And the answer is, if you have to ask the question, disclose it. And people say, well, won't they counter? Won't they try to reduce the price? Yes, maybe. Maybe that's a $5,000 reduction in the price. But here's the problem. You don't disclose, and you have that $5,000 liability, and your client ends up in my office, and I say, well, yeah, it's now going to cost you $8,000 just to mediate it. Seriously, this stuff happens. So one of the things you disclose, because in a market today, maybe the buyer wants to cancel. There will be another one, and it probably won't be very far away. Another common thing that I've been preaching lately, because one of the questions that comes up is, well, you know, people are sending their assistant out to do the AVID form. Come on. Don't do that. I shouldn't hit myself. I did that last week and it hurt. You know?
So we also had a question from the Central Valley that said, well, do the buyer's agents even need to do an AVID?
The answer's on the next slide, which is why we're trying to get there. Oh, no, stop.
Oh,
One more.
wait. Hooray. Yes, of course they need to do one. It's in the contract. Paragraph 10A2, I remember, contracts are your friends. Review them. It says, nothing relieves a buyer's broker from the obligation to conduct a diligent visual inspection and either disclose on Section 4 of the TDS or AVID material facts affecting the value and desirability of the property. So, I don't know, we were kind of flabbergasted when we heard that question. And so we thought we'd point you to the actual terms of the contract, because that is your obligation, right? Sir? Well, that's kind of good for you. Yeah. Right. Yes.
If we represent the seller and the seller decides to do a test inspection, whether with or without our advice, and now we have a pest report, termite pest report, could the seller keep that and not disclose it to the buyer until they finish or they fix everything on it?
No. So the question was, she represents seller, seller does a pest, seller does not disclose that to buyer. So there's things to fix within that pest. They have in fact fixed them, but still have not disclosed. I would absolutely give them that. No question. Exactly. Yes. Yeah, don't send an Avid after the fact. So, as you can see, such a simple form creates so many inconsistencies or different methods of practice, but use common sense. And when you speak with your clients about disclosures, common sense. If you think you should disclose it, disclose it. Let the market decide what to do with the disclosure. And that's your skill as an agent or a broker to then begin, if you have something bad, then you either negotiate that away or you move on to somebody else. Remember, small liability bubble. You want the transaction to close and not have it haunt you because you didn't disclose something, okay? Yes?
Follow-up question. If the first inspection came with issues, and then the seller hired that company to do the work, and then now the report, we have a new report that's clear. Can we just give the clear report without the report?
No.
Give it all. No. Provide all of it.
Right. Yeah.
Repeat the question.
So the question was, we got initial pest report, needed stuff to be fixed, stuff was fixed, new pest report with nothing to report. Do they need to give the initial report that said things they need to be fixed? Yes. So, we could spend all afternoon on disclosures. And we have horror stories to tell about on the buyer side and on the seller side. We'll do maybe one more question right here in the front.
How much do you charge the retainer for general counsel advice?
We'll talk about that afterwards. We're not here to market. We're really not. Oh, it's cool. Well, no, you're good, and so is he. So, we could talk about this all day. And again, horror stories. I've got a non-disclosure bat case right now.
Yeah, that's an interesting one.
Well, so, all right, just a little aside. So I represent the seller. She's 65 years old. She lived in a 5,000 square foot house in the foothills, 30 acres, tall pines, beautiful place, outdoor decking, 30 acres, gorgeous. Lived there for 20 years with her husband, who was 75 and had recently passed after a long illness. She sells the house. 30 days later, she gets a lawyer letter saying, you failed to disclose bats at the property. Bats. And that the guano was so pervasive, and the noise, and that at dusk they come flying out of the house, and we want to rescind, or we want $50,000 in damage. So I get my 65-year-old client on the phone, and I start to ask her questions. Did you ever see any bats? No. Did your husband ever see any bats? Absolutely not. My husband likes to use the hose on the property, and it would take him forever. And he had nothing else to do, so he would go around 2 o'clock or 3 o'clock in the afternoon and water the plants through dusk. Why is dusk important? That's when the bats come out. Did your husband ever see any bats? No. If you were made aware of the bats and you knew that you had bats, would you have fixed the problem? Absolutely. Do you have the money to fix the problem? Absolutely. My grandkids come over and stay the night. We hang out at the deck. If I would have seen a bat, I would have disclosed that, or we would have gotten that fixed. The craziness of all of this. So the case is pending, but the bottom line is for your clients when they disclose, it's a fraud standard. They had to have lied. A material fact that I know about, that I know you don't know about and couldn't discover, and I misrepresent to you and lie that that's not happening to induce her to buy the property. You have to prove that they lied. That's hard to do. Plus, it's a higher standard of proof. So remember, we have OJ up here, beyond a reasonable doubt. Preponderance of the evidence down here, 50.01%. But fraud is clear and convincing. It's in the middle. You've got to prove that they lied. Number one, hard to do. But on the buyer's side, from the seller's side, if somebody's going to lie, they're going to lie again. But again, disclose, disclose, disclose. They don't have a bat case like I do. So we've already seen that one. Okay. So we have a green leaf. That's a maple leaf, I think. And the IRS symbol. And I put the green leaf before the IRS symbol for those users out there before they did their taxes. So we're going to talk about IRS stuff first.
So I always get the boring topics. Taxes. Which was funny because last Tuesday was tax day and we were in Stockton and Modesto talking about this and how fitting was it at that point in time. Right? So, December of 2017, Tax Cuts and Jobs Act. They have thousands of people working on it, and why they couldn't come up with a better name, I don't know. But 3 things happen. 1, reduction in the individual tax rates was a good thing. In the middle tier levels, it was an average of 4% reduction for individuals, which is a good thing because they are seeing bigger paychecks now. Reduction in corporate tax rates. Corporations did well. But the one for you to be aware of, changes related to deductions. They were significant, and they're important. So this is really not that important. I just find it interesting, which is why it's here. The individual tax rates, which were reduced by an average of about 4%, will sunset and expire in 2025. Why is that interesting? Well, Mr. Trump apparently thinks that he's going to be a 2-term president. Maybe he will, maybe he won't. I don't know. That will be figured out in November of 2020. But if he is a 2-term president, January 21st of 2025 is when the next president will be sworn in. And nobody likes to have increasing taxes in a new administration. It's a bad thing. Corporate taxes. Corporate taxes are the ones that did well. The corporate tax rate dropped from 35% to 21%, and unlike individual tax rates that expire, the corporate tax rates were made permanent. However, not all corporations are created equal. S corporations, pass-through entities, LLCs, partnerships. What most of America is, they will not benefit from the reduction in the corporate rate. Their tax rates stay the same. They're pass-through entities. Well, that's not fair. So what did we do to try to fix that? What they did is they came up with this thing called QBI. QBI is a qualified business income. It's not a straight line deduction. It's a mathematical formula that says that, okay, you're a pass-through entity, you're a partnership, you're an LLC, you're an S corporation. You're taking a portion of your profits on a K1. You're not benefiting from the corporate deduction, but we want to give you some sort of a tax break. So they create a QBI to say, if you are a married couple, up to $315,000 of your pass-through income, or if you're a single person, $157,500, will be subject to this potential 20% deduction on that pass-through income. You go, great, 20%. I'm married. I can make $315,000. I can get 20% off. That's 60-some thousand and change in deductions. This is wonderful. Life is good. You need to read more. And when I say you, your accountant does. Because that bill was like 2,100 pages long, and I don't think there's a person in America who's read it yet. What they've done is they've tethered your qualifying income to what you pay yourself as a reasonable salary. And right now, what it looks like it's going to be at is if you pay yourself a W-2 wage as an S corporation, and that W-2 wage is $100,000 that you pay yourself, then up to 50% of that amount would be subject to the QBI, so $50,000 bucks. So if you make $150,000, pay yourself W-2 of 100, you pay your payroll taxes on that, and you take $50,000 in a K1, 20% deduction on that $50,000, $10,000 in deductions. It's getting very, very complicated. I read a Forbes article for about an hour and a half, tried to figure it out, and said, I'm going to call my accountant. That's their job. The deductions. This is the big one. We're going to talk mostly about number 1 and number 3. Number 1, most of your personal deductions have been suspended. They come back when your tax rates go up again. Many personalized deductions, including home office expense, licensing fees, professional society dues, work clothes, and moving expenses are suspended as a result of the new law. You go, this is not good. I use those. The big one is the home office expense. In your profession, many of you probably deduct your home office. Now, the reality, is the home office expense actually eliminated? No. Here's what you have to do in order to take that home office expense deduction. That home office has to be used 100% of the time for business purposes. I can see the scenarios now. It's May 1st. I need to pay my mortgage. I'm going to run into the office. I'm going to log on to my computer. I'm going to go to my personal bank account, and I'm going to pay that mortgage. Whoops. Now it's not used for home office. It's now being used for personal. Oh, my kid or my grandkid needs to use the computer for homework. It's not used for business purpose. The question is, how do they police it? And that's a good question. I don't know. What I do know is that you have to sign under the penalty of perjury that your taxes are correct. That's a problem. Plus, the nominal value that you probably get out of the deduction is probably not offset by the interest and the penalties if you ever get audited. So my advice, don't do it. And then go talk to your accountant. The other big one that affects California is the SALT deduction. How many of you know what I mean when I say the SALT deduction? Everybody's hand should be up because it's in red on the screen. Stands for state and local tax. Prior to the tax reform, here in California, where we pay loads of taxes, you could deduct 100% of your property tax and your income tax on your federal return. That's great. We have Prop 13. In the county, in the area that I live, the average home price is about $648,000 now. I might need to sell. So $648,000. That's a $7,000 property tax. $7,000 and you're capped at $10,000. That leaves you $3,000 of income tax to pay at the state level before you run out of a deduction. That's going to be a potential problem. Not this year. This year, consumers are looking at the paychecks that they have today. That's good for buying power. That's good for purchasing homes. There's more discretionary income. Where this could create a little bit of a problem is next April, when deductions that people used to rely on are no longer available and their wallets begin to tighten. So just be aware of these things as you're talking to your clients, as you're thinking about them for yourselves, and reminding them, we need to talk to accountants. We need to talk to the professionals, because there's a lot of changes and we don't understand the full weight of them yet. What does this mean for the real estate professional? What does it mean for you? Some of you operate as sole proprietors. Some of you operate as S corporations, and hopefully none of you operate as LLCs, at least not as a real estate agent. The DRE frowns on that. Will the agents continue to operate as a sole proprietor? We remember that all of the deductions that you lost as an individual, the corporations kept. Corporate entities get to use those deductions. So is there an economic value for you to change the way you operate to an S-corp? From a tax perspective, maybe, maybe not. Is you want to make sure you talk to your financial professionals, talk to your accountants, examine what is the value of the loss deduction versus the value that I would get back at the cost that I have to pay to keep that S corporation. From a tax perspective, maybe it's beneficial, maybe it's not. I can give you a whole list of reasons on liability why it is good, but that's for another class on another day. Question over there. That's correct. So the question was, do you have to have a corporation, California corporate? You have to have a corporation. You can't use the LLC. You may be able to be incorporated in Nevada, but then you would have to be registered as a foreign corporation doing business in the state of California. $800 a year. It's always $800.
Okay. Everyone's favorite topic saved to last. Cannabis. Is cannabis legal? Maybe. Maybe. So, I'm going to take you back to your 9th grade civics class. Your favorite government teacher, right? State v. feds. The 13 colonies trying to draft a constitution. The Articles of Confederation, that failed. Then they drafted the Constitution. Why? We weren't just one big state, we were 13 colonies to turn into states. Remember, part of the reason people immigrated was to avoid the central power of the king. So when they got here and they're trying to set up a government, they were afraid of centralized power. But at the same time, remember, there were fights between the big states and the small states. And now we're going to base representation on population. That's why I have Congress and then senators to balance that out. So we came up with this document. It's called the Constitution. It's a beautiful thing. It's imperfect, but it's great. So we have to look to the Constitution to figure out, is cannabis legal in California? So within the Constitution, the body of it is what's called the Supremacy Clause. The Supremacy Clause says that federal law is the law of the land, because they needed to have some overarching governing structure to hold these 13 colonies together, or else it wouldn't have been 13 then states. It would have been 13 nations, right? They had to have something to do. So they used the Supremacy Clause within the body of the Constitution itself to outline that federal power. But the Constitution also was made up of amendments. Amendments are critical. First Amendment, right? Fourth Amendment, illegal searches and seizures. And the 10th Amendment. The 10th Amendment was a compromise. a compromise between the supremacy clause and the power of the individual states. And within that it says, whatever power is not given to the federal government is then reserved to the states. And digging deeper, going deeper into the weeds, is the commandeering clause of the 10th Amendment. And the commandeering clause says this: hey, federal government, you cannot commandeer a state government and their agencies to influence and impact and enforce federal powers. So you can't take the federal government and it can't say to California, marijuana, cannabis is illegal, fight that pot war. They have to do it themselves. So here, supremacy clause, law of the land, 10th Amendment, reserved to the states, no commandeering. That's the argument for why cannabis is now legal in California. So what happened? California begins to build its regulatory scheme. Local agencies also have their own local regulatory schemes. California's law says that that counties and cities can pass ordinances that are more restrictive, but not less. So here in the county, there are certain restrictions. The city are certain restrictions, and that's for all 52 counties. And imagine how many cities are within those counties. So this is nuts. I was on a cannabis panel a few days ago, or last week here at SAR, and a representative of the industry was here. And he said that his biggest challenge is to keep up with all the regulatory schemes and changes, because they change so quickly. It's a hard thing to do. So, the Cole Memorandum, again, federal versus state. In the Obama administration, the Department of Justice issued a memorandum, and it said basically this: hey, Department of Justice and Resources, hands off those states with marijuana laws. Only use your power if across state lines illegally, gangs, kids, guns. That makes sense, right? So unless it was in those particular areas, DOJ, back off. But what happened? Trump was elected. Jeff Sessions is now the Attorney General. He revoked the Cole Amendment. So now that opens the doors back for the DOJ to try to enforce it. Will they? No. Why? Money, right? The money's huge, huge. But another interesting thing that I learned on the panel was it's just not the grow. It's the industries that support the grow. So we have commercial real estate. Those warehouses are going crazy right now. Prices are valuable. We have commissions made from those sales. We have transportation. We have security. We have equipment manufacturing, retail stores, and all of those employees that are getting paid, and the taxes, and to buy houses, and commissions to you. The money's too big. So will the Fed step in? I'm not sure, but there's some recent developments. 2 weekends ago, the senator from Colorado, where cannabis is legal, he chairs the Senate Judiciary Committee, and he's holding up 20 of Bush appointments. Why? Trump, pardon me. Holding back 20. Trump ain't happy about that. So allegedly a phone call was made from Trump to the senator in Colorado saying, I'm going to put the Cole Amendment back into play. Politics makes interesting bedfellows, doesn't it? So you give me my nominations, let them through. I'll keep my hands off Colorado. So that's interesting. A couple more things. Fed legislation is now being introduced. Chuck Schumer introduced legislation on 420. Not kidding. To decriminalize cannabis. So not legalize it outright, but allow the states to determine. See the theme here, the constitutional theme? We'll let the states decide. But Cory Booker from New Jersey introduced the Marijuana Justice Act to fully legalize it nationwide. So 2 different ways to go here, but it just shows that things are moving forward. How does this impact us? Forwards or backwards, depending on what you're thinking. But it's moving forward. A lot of questions we get about leases. Okay? Must you rent to somebody with a medical marijuana card? Absolutely not. No. Why? Still illegal. It's a Schedule I drug on the federal level. But people will say, I have a medical marijuana card. I'm a protected class. No. Protected class, race, religion, sex. Not medical marijuana. So you don't need to lease to somebody. Okay? So, also, check your applicable laws. And Keith, what about the legal parts of the contract that we need to have in there as property owners?
Yeah, when you're representing landlords or you are a landlord yourself, you need to make sure that your lease has the proper default clauses. In October of last year, Governor Brown signed a law that made cannabis a legal subject matter of a contract. What does that mean? Well, in order to have an enforceable contract, it has to have a legal purpose. It used to be that cannabis was illegal. So any activity related to cannabis was therefore illegal and would be a breach of the contract. Or create a contract that's unenforceable. Alex goes to sell me heroin. He doesn't provide what he's supposed to do. So I sue him to force him to provide the heroin or to give me my money back. And the court looks at me and goes, that's illegal. We can't do that. We cannot be an instrument of that illegal activity. That changed for cannabis last year. And why is that important? Because in the car form, for the lease, it has that standard provision. Any illegal conduct is a default of this lease and we can terminate it. And you go, great. It's still illegal at the federal level. We can terminate this. But there's a problem. There's also a governing law provision. Governing law provision says we are going to interpret this based on the laws of the state of California. And in California, it's now legal. Gets you into the wickets. We do know that the feds are enforcing civil forfeiture. It just happened here in Sacramento 2 weeks ago. The FBI and the U.S. District Attorney for the Eastern District of California, McGregor Scott, he's a very nice man.
Oh, man. He's a serious dude.
They just raided 100 homes. And last Tuesday, as I was driving from Modesto to Stockton, I got a text message. And I did not read it while I was driving. I waited until I was parked. And I have a witness. We parked, and I grabbed the text, and there's a complaint. One of the owners of one of those homes is having their property forfeited right now. So it is being enforced. Now, we can get into the backstory of what happened, and it's significantly different. But we do know that they're enforcing. So what you need to do is have that conversation with your owner, with your client. What is it that you want to restrict? Because you need to build that language in. You need to have a provision that says any illegal activity as determined by the laws of the United States of America shall constitute a default of this agreement. Marijuana is a violation of federal law. Good. We got a specific clause. You need to have the second clause that's already in there. Any violation of laws as determined by the laws of the state of California shall be a default of this lease. Then you want your blanket provision. Any use or possession, including but not limited to use, cultivation, growth, manufacturing, distribution, whatever else, and then cannabis shall be a default. You need to have that blanket provision in there to create that specific default so that if there is a situation You have the ability to terminate that lease using the terms of the contract. No.
If you're okay with them to grow, we'll talk about that, and that gets tricky, okay? Local laws. So, City of Sacramento, indoor grow, no outdoor grow. 6 plants, total, not 6 plants per occupant. So 6 plants total. And here's kind of some of the interesting things about this ordinance. It's got to be inside. The door has to lock. You must have a ventilation system to prevent odor from exiting the structure. It's got to be inspected and approved by the building department. Talk about the money that that's going to require, right? For 6 plants. I don't know anything about growing marijuana, but the pictures that I've seen, plants can get big, and they smell. So you can see why they would build this into the local law, right? Because you don't want to be sitting on your patio and smelling the cannabis grow from your neighbor. So this is important. But another kicker here is the administrative penalties. It's $500 per plant over 6. And the big kicker is the owner of the property is strictly liable. So, scenario, you're a property manager or yourself have 4 rentals and you inspect them once a year. Because remember, when you're renting your property, your tenant has the right to quiet enjoyment. You just can't be strolling over there to see what's going on. So you inspect once a year. Is that going to be enough? So if there's strict, Keith will talk about a particular workaround to this, but let's say that you do your due diligence. You screen your tenants. You are over there twice a year, but your tenants are crafty, and they begin to have marijuana grows because you've been there, but it was 3 months ago. And the house is raided and busted. And they find 1,000 plants. 1,000 times 500, I'm not a math major, I have no idea what that is, but it's huge. Right? You, as the owner, are strictly liable for that debt. Strictly liable. Sir? Great. So imagine this. The homeowner is strictly liable. We represent property management companies with hundreds and hundreds of properties, right? And so suddenly homeowners or rental property owners are getting dinged for all of these fines, and they're strictly liable. Is that going to create a chill on the rental property purchase market? Yeah, because you've got an owner who does everything right, or maybe yourself does everything right, and you just happen to have one bad tenant, and they ding you. And so suddenly the profit that you made from the equity and doing everything right and maintaining the property and long-term tenants, that all goes away. What's this going to do? My feeling is this is going to have to change, right? There has to be built in some innocent owner provision, or there has to be inspection logs that you file with the city under the penalty of perjury that I was there every 3 months to inspect the property. I don't know. Sir?
So on the commercial side, are the laws different?
Yes. Yeah, I didn't get into commercial stuff here. The city of Sacramento has an extensive administrative portion of the code that pertains to the commercial side. I just sort of did residential.
So these are laws just in the city limits?
Correct.
Outside the city limits, what is?
It's county. And county, it's weird. I read the county statute a couple of weeks ago. So state law says 6. Remember, you can be more restrictive at the local level but you can't be greater than. But the county of Sacramento says 8. I don't know. I don't know why that is. But also no outdoor grow, only indoor. and the county says no commercial cannabis, well, the city says yes. Yes. Oh, well, if they're,
Well, that's a great segue into that
Yeah.
story. So the question is, how does the owner get back the property? Because you have to know what's going on, right? So if you can only inspect once or twice a year, how do you find out? I was having this conversation because it was a couple days after a panel I sat on. At the end of January, I sat on a panel talking about cannabis and how it was being regulated at the city level. And we had two very nice police officers from Sacramento Police Department there. And they were recently appointed to the marijuana division of the Sacramento PD. Yes, it exists. And so they told this story, how just a day or two earlier, they had raided a property. It was a known grow house. And they found whatever 396 times 2 is, plus 6, because the 6 are free. And that owner got a $396,000 fine. And so we have these conversations. Look, we have a thriving rental market. We have to protect these owners. So I was speaking with one of my investor clients, and we were trying to figure out how are we going to protect them? What kind of tricks or tips can we put into practice that will solve or help abate some of these issues? Because nobody wants to be on the receiving end of a $396,000 administrative fine that's going to become a lien on a property. And so we were talking, and he kept coming up with these ideas. I said, no, you can't do that, violates quiet enjoyment. No, you can't do that, violates quiet enjoyment. And then something went off in our heads and goes, it's Sacramento. It's hot here. Now, I'm from Seattle, and it doesn't get hot. I don't know what AC was, didn't really know what it was used for until I moved to California. And he goes, I have HVAC systems in every single one of my rental properties. And they get serviced by a very nice HVAC company 3-4 times a year, every quarter. Ding, 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 ding. We're going to fire the HVAC guy. Because there's nothing that restricts routine maintenance. The owner can do the routine maintenance himself. So he fires the HVAC guy. He now is changing the filters in his HVAC units in his rental properties every 3 months.
it's a pretty smart workaround. Because remember, we're balancing quiet enjoyment with you as property owners to protect your backside from tenants that may grow and this threat of civil forfeiture and penalties. So it's a big deal. So, some things to think about as practitioners. Disclosure. You can't get away from it. It's like gum on your shoe. So, disclosure issues. Smell. If you're smelling marijuana from next door, do you need to disclose that? Yeah. Light. So the city ordinance says that the light from the grow room can't escape to the outside. But what happens if you got somebody that the light is escaping from the outside and they've got halogen lamps in there at 3 in the morning that goes right into your bedroom? You think you need to disclose that? Sure. This is an interesting one. What about the stigma? Well, is there a stigma? Right? Some people may say yes, there is a stigma. Some other people may say no. So there's a licensed, inspected house next door. Your neighbors have 20 years. They got all the building permits, and they grow marijuana next door. And you know that. Do you need to disclose it? I would. Here's how, again, getting into the weeds. So they grow marijuana next door. They've got a 14-year-old son. Your potential buyer's son is 13. They're going to be buddies. So now, sleeping over at each other's houses, riding bikes together, going over their barbecues, and they're growing marijuana at the house. Is that a stigma? That's tough. The laws have changed. Ideas about cannabis and marijuana have changed, but not for everybody. So think about that. Also think about, we had this come up, where somebody was selling a residential piece of property, but it was within a green zone, meaning that commercial grow and manufacture and processing was nearby. Do you need to disclose that? It's a tough one. It doesn't impact your residential. But again, the stigma of living within a green zone and down the street, they manufacture marijuana. Tough issue. I live in Hollywood Park, and there's a Track 7 brewery is near my house. And across from Track 7 brewery is a warehouse. They want to put marijuana in there. So it's everywhere. So you need to think about this stuff. So again, your next door neighbor, proximity to the green zone, makes practice of real estate interesting and ever-changing. Oh. Thank you. We appreciate you.
Thank you. Remember, if you want a copy of the PowerPoint, drop your card off in the box out just outside the door, and we'll email a copy.